My name is Kathleen Hunker, and I'm a policy analyst here at the Texas Public Policy Foundation, specifically in its Center for Economic Freedom. I'll also be your moderator for the next hour or so as we discuss how to protect private property and Texas Miracle. A quick announcement before we begin: if you are live tweeting this panel, the hashtag is TXPO2015. 18 months ago, I had the good sense to move to Texas. Only I wasn't alone. Over the past decade, Texas has attracted 1.2 million new residents from other states, each one recognizing, as I did, that there are certain opportunities that can only come from a low-tax, low-regulatory climate. Indeed, studies now show that 1 out of every 4 Americans moving state to state comes to Texas. And according to the U.S. Census Bureau, the Lone Star State now boasts 7 of the 15 fastest-growing cities in the country. That expansion, in many respects, has had a marvelous impact on Texas culture. It's inspired new art scenes, attracted new industries, and has spurred a whole new generation of entrepreneurship. Yet at the same time, that expansion has put a great strain on existing infrastructure and may have in fact transformed some communities in ways that current residents neither expected nor desired. In consequence, many Texas cities have found themselves in quite a quandary. How do you balance the sanctity of private property rights, an institution that not only defines Texas's character, but was also a large part of its success as a refuge for dreamers, with the practical needs of providing common public services such as roads and schools? How do you weigh the rights of an individual to sculpt his land as he sees fit, with the recognition that for many, the beauty of democratic rule is the ability to create a community that aligns with your values, aesthetics, and ambitions? Moreover, what does it mean for the Texas property owner when local governments bypass the private market and take through law what they could not achieve at the bargaining table? Well, we've assembled a dynamic team here to unravel those very questions. One that will assess the 4 corners of the property rights debate: the legislature, the property owner, Texas cities, and the realities that is land use policy in practice. By the end, our panelists will have peeled back each layer of the property rights debate, identifying the stakes, and more importantly, charting a course ahead for this upcoming legislative session. Each panelist will have 12 minutes, and then we will then open the floor to the audience for Q&A. Let's begin with Senator Lois Kolkhorst.
Thank you so much. How many of you were at the luncheon just a few minutes ago? Well, I don't know what you thought of it, but first of all, is Kent Hance not hilarious? He's a funny guy, and so we've got some real experts up here, and I may be the Kent Hance of the panel. This is not a laughing matter. Our moderator stated a lot of the facts of balancing what we have in a Texas miracle with people moving here every day, and then private property rights and the sanctity of that. I have the pleasure now of being a senator of 21 counties. One county is seeing tremendous growth, and it's spinning out to the other counties. And I will tell you that just yesterday I did a long tour with a group that is it's a small city right now, but it's going to probably by the year 2025. It has 6,000 residents today. Probably will have over 100,000 by 2025. And I was with the mayor and the city manager, and talking about the issues that they face, and obviously cities that you'll hear from today, and counties and utility districts and other people are struggling with that. I want to say, give you a little bit of history and then a couple other insights. In the 82nd session, we passed SB 18, which required entities with eminent domain powers to provide a submission to the Comptroller's Office. We recently pulled that report, and over 9,000 entities claiming eminent domain authority have submitted information, including non-governmental entities. So 9,000 entities in the state of Texas have some sort of eminent domain authority. Of the responding entities, 81% or with governmental bodies, mostly municipalities, counties, utility districts, and housing authorities. Many claim eminent domain authority under multiple laws, including Texas Constitution, Local Government Code, and the Water Code. Among the non-governmental entities claiming eminent domain authority, there were water companies, gas pipelines, and several toll road corporations. Certain toll road corporations can currently exercise the power of eminent domain despite the fact that the legislature revoked eminent domain authority from those toll road authorities in 1991 because of a grandfather clause. That was back in the 72nd session. And so you can see that there are there's a tremendous amount of authority out there to potentially take your land. I deal with co-ops, rural co-ops, co-ops that aren't so rural anymore. And recently I was dealing with one that said, we've never used eminent domain authority. Wow, I tip my hat to that co-op. But I will also tell you that it is the threat of eminent domain authority that sometimes make landowners cut a deal that they otherwise might not have. Right now, in Old House District 13 for me, and Senate District 18, I'm dealing with two counties. One county I no longer represent as a senator, but I've had them in my district for over 10 years, and they are facing a new toll road, a train, and a power line. All three different pathways going all different directions, taking land from landowners. And I deal with these phone calls. And you listen to it, and it's real emotion and it's real passion. That one constituent called and said, right where the power line is proposed to go, one of the pathways is over the house that we're going to build. I already have architectural renderings. That is our pad site. What are you going to do about that? And you can feel the helplessness in their voice and when you meet with them. And yet, you deal with the people and say, well, the train's going to be great for Texas. The power line has to be built. The toll road authority, the toll road's going to be wonderful. It's going to get you to Texas A&M more quickly. All of those things have to be balanced. And so one of the things I want to highlight today as potential answers is, we made some steps in recent years, but I don't think we've gone far enough. And when we deal with authorities that have eminent domain power, I filed a little bill called HB 20. And HB 20 was not that complicated a bill. It basically said, if you're going to condemn my land, you have to state the purpose for what you're going to condemn it for, and you actually have to use it for that purpose. Does anybody feel that that's unreasonable? When I filed that bill, you would have thought the sky was falling. I mean, the sky was falling. If you're going to condemn my land for a park, then you need to use it for a park. If you're going to condemn it for a pipeline, use it for a pipeline. If you're going to condemn it, if it's a city, and you say we need this land because we have to have our maintenance operation there, great, use it for that. And if you don't, then I get to buy that land back in a certain said period of time. And it's not tricky. If you pass a resolution in city council saying we're making progress, that doesn't qualify to disqualify me from buying my land back. And the hide the ball thing. One of the difficulties that I see with constituents that I represent is the lack of sometimes transparency and forthright, not by cities, but by the powers that we give in the statutes that allow them to hide the ball. And so while we've made some progress, there were a lot of compromises made in there that make it so difficult that the landowner might not even know that they can buy the land back. And so plain and simple language, HB 20, I think, was another good start. Got a hearing on that bill. Never got a vote on that bill. That bill was dead the day it was filed. And I think that there's some common sense solutions that empower the landowners to give them a true voice in this process that will be good for the future. Everybody in here remember Kilo versus New London? Yeah, I remember where I was driving, like when a president got shot or the space shuttle broke up. I remember where I was. I was actually in Bastrop County, right there about to get on 21, and when I got the phone call of how the Supreme Court ruled on that. And the reason that I remember it so well is I was in economic development for a number of years. And while economic development is a very important function of what we do, and it's part of the Texas miracle, I can tell you that eminent domain authority should not be used for economic development. That's really not, that's an abuse of that. So in the wake of the private property rights crisis that we saw at that point, you did see a number of states that made changes, including Texas. But, you know, Alabama, Arizona, one of my favorites, was passed the Private Property Protections Act, which was Proposition 207, prohibiting the government from exercising eminent domain on behalf of a private entity with almost no exceptions. California passed an amendment that even California to the state constitution to prohibit the state from using its eminent domain power to acquire an owner-occupied residence for the purpose of conveying it to a private entity or a private property. So you saw each of the states reacting to that, and we did the same here in Texas. We consistently have enacted those reforms. SB 7 in 2005 was a good start. Prop 7 followed, and Prop 11, and then SB 18. And so while we're making progress along those lines, I think the pressure of the growth that was stated earlier is going to make us, or should make us in the legislature, act and put in even stronger rights for the landowner to have some say. Even like in a loser pay scenario, if I go to the court and try to fight a big government entity, you heard, was it Graham or Hance that said, you guys act like it's your own money. When a government entity has limitless budgets of just, fighting you in the court, and you're sitting there going, I don't think I can fight this. I don't have the money. Hiring a lawyer is going to cost me this. You usually settle. You usually just say, hey, look, I'm going to get the best deal I can, and we're going to move on. But when you're talking about people who, it doesn't matter if you just came here a year and a half ago. If you've bought land, it's important to you. I represent, as a fifth-generation Texan, I represent a lot of people who have had the land in their family since the Texas Revolution. And they really don't want to give it up for the next great thing that's coming through. And, the frustration that I have in what I call the micropolitan areas, those areas just outside of the Harris County area, those areas just outside of the Metroplex in North Texas, is that, we end up getting the power lines, and we end up getting proposed bullet trains. And we never seem to use the same pathways of the power line that was already there. Well, why can't we use that power line, footprint, and just put the next power line right next to it? Or why can't we use road frontage and put an elevated train? Oh, we just can't do that. And I think that we're going to have to get with Texas and land fragmentation and the things that we're seeing, we're going to have to get better about those things. So I'll leave it to the rest of you experts to tell me why I'm so wrong. I think we're weak in this area. I do. I think that Texas could do better, especially since it is such a part of our heritage. 9,000 entities, too many people have eminent domain authority. Fire away, guys.
Thank you, Senator. Next up is Luke Ellis. He is a partner at Johns, Mars, Ellis & Hodge and focuses exclusively on representing Texas property owners facing condemnation proceedings, and is widely recognized as one of the top lawyers in the state practicing in the area of eminent domain.
Thank you, Kathleen, and thank you for the invitation to speak today. Senator, I'm not going to tell you how wrong you are. I'm going to tell you how right I think you are. And in fact, I'm going to propose a couple of, I'm going to present a handful of what we perceive as significant problems for the client base that we represent. And in conjunction with that, I'm going to present a handful of ideas on how we could potentially address them, and even propose a few ideas that other states have enacted. Again, as a quick background, my name is Luke Ellis. I'm with Johns, Mars, Ellis & Hodge. The lion's share of what our firm does is represent Texas landowners when their property is taken by the government. That is all that I do. It is all I've done since 2009. I'll tell you, before 2009, I did have, so you don't think I'm purely from the perspective of a property owner, and Chris, from the perspective of entities that take property, I did for a stretch work for a larger firm that represented both private property owners and their interests, as well as a few entities that had the power to condemn. So I have seen a handful of cases from the side of the entities that can actually take the property. Now, there are a number of frustrations that our clients face every day. We live this month to month, week to week, day to day, hour to hour. And what we often see with our clients are frustrations regarding the amount of compensation that they've been offered by the government. There are serious concerns with right to take challenges, no doubt, and I don't mean to diminish those concerns at all. The senator referenced Kelo, and for years and years before Kelo, lawyers like myself labored in relative obscurity because eminent domain wasn't on the tips of tongues of folks until after Kelo. That changed. Now, a lot of the discussion post-Kelo has centered on one of the two core issues in an eminent domain matter, which is, does the condemning entity have the right to take? This is a very serious issue. I was equally offended by the Kelo decision, as probably many of you all were in this room. However, I am here to tell you that for the vast, vast majority of Texans whose property is condemned, the fight isn't over whether the entity has the right to take or not. There certainly is an element of that exists today, but in the vast majority of instances, the clients that we represent are fighting not whether the entity can take the property, but rather whether the entity is providing just compensation for the taking itself. If TxDOT condemns you to build a new roadway or to expand a roadway, you're unlikely to have a strong right to take challenge. Now, there may be a significant issue regarding the valuation that they've offered, okay? So let's go through a handful of different approaches, and what I'll do is talk to you about one or two of the different challenges and problems that Texas landowners face, and again, what is truly the balance of a community benefit versus the challenge of being sure that a private property owner has been made whole, okay? And that's ultimately what we're most concerned with. This is whether just compensation under the Fifth Amendment to the U.S. Constitution and Article 1, Section 17 to the Texas Constitution has been met. Now, how do we know whether it's been met or not? The cases say we ought to make a landowner whole. That's at its core principle. If a landowner's property is taken in order to benefit the public, can we make that landowner whole for the taking? I'm here to tell you I don't think that that happens in your typical condemnation case. Let's go through a couple of numbers, a couple of things to make this easy for you. And I'll give you guys some examples of real-world cases that our clients face every day. Client has a property. Property is worth $1 million. We'll use easy numbers. Government comes in to take that property to build whatever infrastructure project you can imagine, high-voltage power line, the Aggie Expressway, some of the other, the SH-130 to the east side of town. Government comes in and offers that landowner $500,000, okay? And I've seen this situation on SH-130 4 or 5 years ago. Landowner paid money for the land. Landowner came out and built themselves a house. 4 or 5 years later, the state announces the building of a new roadway, SH-130, and they came in at about half the value of what the landowner paid collectively for the land and for the house. And their explanation to the landowner was, gosh, we think you overpaid. We think you paid too much for the land when you bought it. We're sorry, that's not the market value today. And we think you paid too much to have the house built. We don't think that's what it costs to have it built. Our number's half of what you put into your property that we are now taking. $1 million, $500,000 offer. Landowner hires an attorney. Landowner hires an appraiser. Landowner fights the case 2-3 years. You get to the end of the road. Landowner achieves a $1 million result in the case. Let's say that result is via settlement. Let's say that result is via jury verdict. In either instance, landowner gets $1 million. Question for everyone here today. Has that landowner been made whole pursuant to the Constitution? Has that landowner received the amount of just compensation to make them whole for the taking? Of course they haven't, because the landowner had to hire a lawyer. He had to hire someone like me to go to court for 2 or 3 years and fight for their right, for their constitutional rights. The landowner, in a case like that, has to hire an appraiser. When the state of Texas or another condemning entity takes you to court and they sue the landowner's got to have an appraiser to counteract the appraisal evidence that is presented. If they want to have a fighting chance, they've got to have an appraiser to counteract the appraisal evidence of the condemning entity. So what we often see even though the landowner hit what I'll call the grand slam at trial. They got the million, they got every penny. They convinced the jury that every penny that they were owed should come to them. They're not whole. They're whatever it costs them for their attorney's fees and whatever it costs them for their expert fees to get to that place. Now, how do folks address that in Texas? Texas, there is one provision in Texas, Texas Property Code 21.019, that provides for the ability to get attorney's fees, but it's only in the very limited context of when a condemning entity condemns your property and then dismisses their petition in condemnation. That's a very rare instance. In a typical case, you can't recover attorney's fees in a Texas condemnation matter. Now, there are other states who employ a very similar approach to Texas in that regard, but there are other states that have taken steps legislatively to try to protect landowners that find themselves in this situation. And there are a couple. Well, and let me pause real quick. I'll show you one example. Folks often say to me, well, gosh, why are we fighting over so much money? Why can't government's got an appraiser, landowners got an appraiser? Why is there such large differences of opinion? I gave you one example, but let me give you another. And these are all based on cases that we're either working on actively right now or have worked on in the recent memory of the last 12 months. North of Dallas, there's a interstate highway. There's 4 corners. We represent the client that's on the northwest corner. That corner's been owned by the same family for 3 generations. They have, as they have the right as property owners in Texas, decided to use that property for agricultural purposes. They have had people for years falling over themselves trying to buy their property, and they have decided simply not to sell and not to develop the property. Now, development came. There's a Holiday Inn on the northeast corner, a BMW dealership on the southeast corner, and there's a McDonald's and kind of a strip center with a bunch of other fast food on the southwest corner. Condemning entity comes to take property from our family. Appraiser condemns our family's property with a highest and best use of agricultural use, okay? So what does that mean? That means they go out and find other sales of agricultural properties in order to arrive at the value that they think they should pay to our client. I can tell you that agricultural sales have a much lower value than sales of property that have a proposed or legitimate commercial use, right? So you see this happen. Now, there are other times where it's not as clear-cut. Here's another example. This is a case we've got on I-35 in kind of the general Waco area, just on the north side of Waco. One of the corners is developed. We represent the landowner. Catty corner to that. 3 of the 4 corners are not developed. Well, that's a harder case for us, right? Is there the equal demand in this instance as in this instance? More difficult of an argument for the landowner, but we would still argue, and oftentimes we think the facts show, that there are huge differences of opinion based on how the appraisers determine the use of the property. And we think that the government's appraisers routinely appraise highest and best use on what would represent the lower end of the spectrum of values, and we see this all the time. Now, back to attorney's fees. There's a number of different states that have different types of systems, and let me say I'm summarizing very lengthy legislative systems in one bullet point. So no, this is a very broad brush 50,000-foot perspective, but in Montana they have a general system that allows condemning or requires condemning entities to pay legal fees if a landowner prevails. Senator, this is kind of the loser pays. In other states like California, they have a more discretionary approach where the judge can award legal fees if if the judge believes in his or her discretion that the condemning authority's offer was unreasonable in relation to what the final jury result would be in the case. Other states have certain threshold percentages where if what was offered, if the final recovery after a jury verdict is more than 10% in Oklahoma or 15% in Wisconsin and so on and so forth, then the landowner can recover fees. So if the offer is $1 million in Oklahoma and the landowner recovers more than $1.1 million, the landowner would have a claim to at least some of their attorney's fees in that state. Florida has a bit more of a tiered approach, and that basically works. To give you an example, if there's a $1 million offer and a $3 million final recovery, in Florida they work off of percentages based on increase over what was offered that's finally recovered. So the first $250,000, they get a 33% recovery on attorney's fees. And then that percentage decreases as the amount that they recover increases. So 25% on the next $750,000, 20% on the next $1 million, et cetera. The point is, in all of these states, they've developed a system that allows for recovery in some mechanism, in some way, shape, or form of attorney's fees. And this is something that I know is disfavored and has been presented in previous legislative sessions. I recognize from all the legislators that I've ever talked with that this is, at least in their view, a virtual impossibility, because some bills that don't go nearly this far kind of die or wallow in the mud. But I'm here to tell you on behalf of, as someone who represents Texas landowners every day facing these proceedings, this would be the one and the biggest thing that I believe could help Texas landowners. Now, there's a handful of other problems that I can address either in Q&A later, or if someone wants to pull me aside. I'll tell you, in the oil and gas industry for eminent domain, unlike high voltage power lines or roads, there's no process for public input for folks whose property is taken for the routing of oil and gas pipelines. There is a process in the context of high voltage power lines. There is at least a public input process for new roads or expanded roads. That does not exist in the context of oil and gas pipelines. There's other challenges with oil and gas pipelines not providing appellate security for a landowner who's condemned. Let me say this. If you're a landowner against a for-profit pipeline company, you take a case through the trial, you get a jury verdict, the case goes up on appeal, and it's upheld on appeal. There are some pipeline companies that will tell you they have no obligation to provide security to actually pay the judgment. Said another way, they tell landowners, yes, we took your property. Yes, we fought you for years. Yes, you beat us at court. Now come and chase the money. Now you've got a judgment, come and collect and start an entire second lawsuit. So with that, there are other things I could address. I'll cede to the other panelists. But I am here to say thank you for your time, and certainly I do think there is work to be done. I agree with the senator to try to even the scales.
Next, we have Christopher Mosley. He is the Senior Assistant Attorney for the City of Fort Worth, where he has cultivated a strong practice in the areas of general litigation, eminent domain, and bankruptcy.
Well, I think I'm the only panelist that is a government employee here today. So would you like me better if I told you that I voted for Reagan? Actually, there's two lawyers who work for, who do eminent domain work at the city. I've been there for 19 years this year, so I've had a lot of experience. Done eminent domain for about 14 years. And for those of you who don't know eminent domain well, and it looks like to me from your reaction you probably know it very well, eminent domain and condemnation are kind of used interchangeably. And simply it means taking private property for public use. Everybody deserves compensation when their property is taken, and the Constitution clearly states that. I will tell you, in my years of eminent domain practice, we rarely see people come to us and say, please do not take our property. Always what they say is, you owe us more than what you say it's worth. That is generally what we hear. And what is interesting, over the last few years, we've had, and perhaps it's because Fort Worth is growing so much, but we have investors moving into areas and buying property that they think the government is going to need. I think that condemnation law is one of the most highly structured laws, areas of practice around, and it's highly regulated by Chapter 21 of the Property Code. And the first step in condemnation is actually good faith negotiations. We used to use that term more often. Now, since Senate Bill 18, we talk about bona fide offers. It's the offers that we have to make, the appraisals that we have to give at the outset of the condemnation process. It's very regulated, and Chapter 21 of the Government Code says if we fail to reach an agreement with the owners, then we have to put that in our petition. If we fail, if the government fails to negotiate in good faith to make our bona fide offers as we're required to under the statute, then the case has got to be abated. And that means it comes to a stop, and we start again with the negotiations. We've never really had that happen at the city of Fort Worth, as far as I know. But if it does happen since Senate Bill 18, then the landowner gets damages. They get their attorney's fees, they get whatever they have paid their appraisal or their expert witness. Even the petition is highly regulated under Chapter 21 of the Property Code. And once negotiations break down and we don't get a deal with the property owner, then we go and file our petition in court. And I will just tell you, as a matter of our practice at the city of Fort Worth, we reach agreements with landowners during the negotiation phase 80, 85, 90% of the time. It is really by far the exception that we have to go and file a petition in court. So once we file a petition, simultaneously we file what's called a les pendens, and that's something that's filed in the deed records that just tells the world that a condemnation proceeding is going on with respect to this property. And this provides action takes it subject to the proceedings. Once the condemnation petition is filed, the court they appoint what's called special commissioners, 3 residents of the city or the county who have some knowledge of appraising properties. And this begins the administrative phase of the case, and this is very different than Texas civil litigation. The trial court actually loses power over the case, and the power goes to these special commissioners. And so once the commissioners are appointed, we work with the commissioners to set a special commissioners hearing. And notice is always given via personal service for these hearings. These hearings, while the rules of evidence do apply, the Texas rules of evidence do apply, in my experience, they're very informal in nature. In fact, I rather think of them as a mediation on the front end of a case. It is really a way for the parties to get together to share what they believe is their valuation for the property that is taken, and to let the special commissioners who are appointed by the court figure out what the value is. Testimony is taken from land agents, from appraisers, and from landowners, but really the only issue in these special commissioners' hearings is the value of the land. It's not the right to take issues that Luke was talking about earlier. So after the special commissioners' hearing, the commissioners meet in private and they decide the value of the property. And then they send the award of commissioners with that value to the court. The court enters it, and the clerk sends it out that day or the next day. When the city obtains the award of the commissioners, we deposit money into the court's registry equal to the award of the commissioners. Now, once that money is deposited into the court's registry, it acts as a right of entry for the government. We can go and begin our public project. Either party who is aggrieved by the decision of the special commissioners may file an objection to the award. This has to be filed the Monday after 20 days after the award. No one files a complaint, then the award of the commissioners becomes the judgment. And I just pause here to say that I think that special commissioners hearings really, really work. In my 14 plus years of practice in this area at the city, we've had 2 trials. That is not very many. So I think that there are a lot of safeguards. I mean, I understand that the system can always be improved. If a party objects to the award of the commissioners, then the case is converted from an administrative matter to a litigation matter, full-blown litigation matter. It's a civil proceeding just like any other civil lawsuit. Jurisdictional challenges, and these are challenges like Luke was talking about to the right to take. These are very common in condemnation life. And these are complaints that a landowner brings that the government didn't follow some procedure. And if they are successful in asserting that, and it's usually done through a plea to the jurisdiction, then the court says, we don't have jurisdiction over this case. They dismiss the case, and the landowner is awarded attorney's fees and whatever expenses they have to that point. For the government, it's the death sentence. It doesn't happen very often. There have been a lot of changes in eminent domain law over the last 10 years, and I think it's pretty safe to say that all of those changes benefit the landowner. It's to make the process more fair, I think. Of course, the impetus for this change, as the senator said, was Kelo versus the city of New London. And I'm sure most of you all are familiar with that. In that case, the United States Supreme Court said it's okay for the government to use eminent domain for economic development. And what was so odious to citizenry, certainly in Fort Worth, and throughout the United States, but certainly in Texas, is that in these schemes, the government is actually condemning property and turning it over to a private corporation. In this New London, which was a depressed area of Connecticut, it was Pfizer who was ultimately going to end up with the property. So now we have a law that says you cannot use eminent domain for economic development. It is very plain. And there's been some other laws effective in 2008. At the onset of a case, we send someone whose property we are seeking for a public project the landowner's Bill of Rights. It's mandatory. There is a sellback provision that became effective in 2004. If the public project is canceled, or if we are not making not taking adequate steps to work on the project, then we got to sell the property back for what we paid for it. We got to make bona fide offers, which I've talked about. We now have to offer relocation benefits comparable to the feds. We've got to serve a copy of the petition when it's filed via certified mail. I think that's very fair. Where there's longer notice periods for special commissioners hearings. We've got to disclose all appraisals on the property. And then we cannot keep offers confidential. And I'll just say in closing that the projects that we do at the city are very bland in nature. I mean, we have to condemn property for roads, for storm drains, for sewers, for water lines, for airports, fire and police stations.
Our last panelist is Randal O'Toole. He is a senior fellow at the Cato Institute and is nationally recognized for his work in urban growth, public land, and transportation concerns. He travels extensively, advocating for free market alternatives to smart growth and central planning. Mr. O'Toole?
Thank you, Kathleen. Although I work for the Cato Institute, I do not live or work in Washington, D.C., and I hardly ever get to Washington, D.C. I live in Oregon, and Oregon does not have a problem with eminent domain. I wish it did, because the problems we have are much, much worse. In Oregon, 96% of the state is zoned rural. And if you own land in a rural area, you're not allowed to build a house on your own land unless you own at least 80 acres, you actually farm it, and in 2 of the last 3 years, depending on soil productivity, you earn $40,000 to $80,000 a year farming it. They're very proud that they've only had to issue about 100 building permits a year since they instituted these rules more than 20 years ago. About 1.5% of the state is inside of an urban growth boundary. And in order to minimize the expansion of urban growth boundaries, they've rezoned lands inside the boundaries for higher densities. Mm-hmm. That means if you own a house in a single-family neighborhood that's been rezoned, you're likely to see apartments starting to pop up in people's backyards. And if your house burns down, you're not allowed to rebuild it. You must build an apartment or whatever is the minimum density of the zone. So they don't rely on eminent domain. They merely take your property through regulation and make you do what they want you to do with your property. And they call this smart growth. Why do they call it smart growth? So that they could demonize anybody who opposed them by saying, well, you must be for dumb growth. Now, right now, 65% of Portlanders live in single-family homes, and the planners have actually set a target of reducing that to 41% by the year 2040, because they think single-family homes are evil and apartments are the way everybody should live. Now, housing is only one effect of this kind of planning, but I'm going to talk about housing prices as a symptom of what happens to all kinds of development and businesses, because we've got excellent data for housing. But when I say housing prices are expensive, I also mean that the cost of any kind of development is expensive. It's probably going to be that much more difficult to get a permit to start a business or anything else. So I'm going to talk about what I call the Coldwell Banker house. It's a house that Coldwell Banker estimates the price of in hundreds of communities across the country every year, about 2,200 square feet, 4-bedroom, 2-bath, family room, 2-car garage, in a middle-class neighborhood. And in Portland, that kind of a house is $190 a square foot. It's about $400,000. That's a lot more than in almost any place in Texas. California does not have statewide land use planning, but they have another set of laws that were an attempt to govern annexation. Cities were fighting over who got to annex what land, and so they created what were called local area formation commissions, which got to govern annexations, incorporations of cities, and municipal utility districts. And the LAFCOs were governed by the cities, and the cities soon discovered that they could keep everything all development within their boundaries simply by vetoing anything that happens outside the boundaries. Wow. So effectively, they created urban growth boundaries. This is the urban growth boundary for San Jose. There's actually land in San Jose that's in the city limits but outside the urban growth boundary. And they said, well, if you want to expand it into the urban growth boundary, you'll have to write an environmental impact report. That'll cost you $15 million. And they wrote the report. This is inside the city limits of San Jose, but outside the urban growth boundary. They wrote the report. The owners of the property spent $15 million writing the report. And the Sierra Club said, well, if you develop that, you're going to have to give us $100 million to buy land elsewhere and preserve it. And it was obvious the city was going to force that requirement on them, so they gave up.
Wow.
So as a result, that same size of a house, a Coldwell Banker house in San Jose, is $777,000. That's what, about $350 a square foot. Now that's today, after the financial fiscal crash. Before the fiscal crash, it was $1.4 million, about twice as much. In other words, about $640 a square foot. Same house, it's just in a community that has restricted development. A third state, Massachusetts, has gone about it completely differently. New England has more or less given up on the... Whoops, how did that get there? Well, isn't that wonderful? I just skipped a whole bunch of slides. There we are. New England has more or less given up on the county form of government. And instead, all cities, all land in New England is under the jurisdiction of one city or another. So the cities have effectively done the same thing as they did in California and Oregon. They've drawn urban growth boundaries and limited development outside those boundaries. And so as a result, in Boston, this house, same size of a house, Coldwell Banker House, is about $628,000 or about $285 a square foot. Now we compare all of this with places like Texas, which have a lot of land, just like Oregon. Only 1.5% of the land in Oregon is developed. It's about the same in Texas. And you can look around in Texas and go to communities like San Antonio and see a Coldwell Banker house is about $200,000 or less than $100 a square foot. Go to Dallas, about the same price, less than $100 a square foot. Houston, for some reason, has gotten to be expensive recently. I'll talk about that in a moment. It's about $110 a square foot. Austin is the most expensive major city in Texas. There's only one small suburb somewhere that, under Coldwell Banker's measurements, have more expensive homes, about $168 a square foot. It's an interesting correlation. The more liberal a city is, the more expensive it is. But outside of Austin, you can find lots of suburbs where housing is about $100 a square foot or less. So there's got a relief valve, which you don't find in San Jose, because there's no place you can go within 80 miles of San Jose or even a couple hundred miles and find affordable housing. Now, what's really going on in Texas is that cities have no authority over what happens outside their extraterritorial jurisdiction. And that, in addition, counties have very little authority to do any kind of land use regulation. So that means there's always land available for development, even if Austin regulates the heck out of the city of Austin and even regulates its ETJ. You get outside and people can do what they want, and it's very affordable. In addition, the municipal utility districts, with a great idea with an unfortunate acronym of MUDs, has made housing affordable. Unfortunately, when the financial crisis hit, this Texas legislature tightened up the fiscal requirements for MUDs, which have made them more expensive, which is why housing in Houston prices have shot up. 10 years ago, housing prices in Houston were almost $100,000 less for a Coldwell Banker house than they are today. So housing prices have shot up. I would argue that it would be better off risking a default of a MUD or two than to make housing and other kind of developments more expensive. Better loosen those requirements. So, first of all, places like the Texas legislature needs to make sure not to give counties any more land use regulatory powers than they have today. Second, it would be nice to loosen up the finance requirements for MUDs. And third, and I think probably my most controversial recommendation, is that cities should be allowed to annex land at will. If you look around the country, the places in the country that have affordable housing and don't have a lot of land use regulation like Oregon, California, and Massachusetts are places where the cities can annex land without the permission of the people being annexed. I call it strong annexation powers. Now, you don't necessarily have to have extraterritorial jurisdictions. Indiana grants cities the right to annex, but there's no extraterritorial jurisdiction. They have to annex it before they get to have any land use authority, and that seems to keep housing very affordable. Indianapolis, you may know, may not know, is the fastest growing metropolitan area in the Midwest. It's not quite growing as fast as Sun Belt cities, but it's growing faster than Minneapolis or Chicago or any of the cities that try to draw attention to themselves. Now, I talk about all these issues in great detail. This is a shameless self-promotion in my book, American Nightmare, which Cato published recently. And I have very few copies of this book here if you want to buy them. Actually, the book is free, but my autograph is $20. I'll tell you that you can buy it on Kindle for about $13, but then you don't get my autograph. You can go to the Cato.org website, and I've written well over 24 papers, and almost half of them have to do with land use issues like this. So you can download those papers for free and get a lot of benefit from reading those. Finally, you can email me at rot@cato.org at any time, and I'll be glad to answer any further questions that don't get handled today. Thank you very much.
We'll now be moving into the Q&A part of our session. However, I am going to exercise moderator's privilege and ask the first question. And this is more to flesh out what was addressed before on how Texas law actually grants private for-profit companies the right of eminent domain in certain cases, particularly when it comes to oil and gas. You see the same thing with electricity and other types of utility companies. And I was just curious if you maybe, of any of the panelists, could clarify what are some of the differences between them. Is there a different impact on property owners, and is it more prone to abuse?
I'd be happy to address that. So there is quite a bit of significant difference in our view. You have a lot of quasi-governmental entities that exercise, as electric utility providers, river authorities that exercise their right of condemnation to build high-voltage power lines. The Senator mentioned some of those. We also see the oil and gas industry. And we find that it depends. At times it can be more challenging to work with the quasi-governmental entity because sometimes it can be more challenging for someone working for the government to make what I would call a real-world business decision. So it really depends. Sometimes we've seen, for instance, in the Eagle Ford shale part of the world, for-profit oil and gas companies actually be fairly reasonable when they approached landowners, and it was largely because there was a business reason for them to build their project quickly, and what they did was they were willing to pay higher values to make that happen fast. Alternatively, from the government's perspective, we sometimes see a more bureaucratic approach, which often means we're the government. We're not in a huge rush. Once we go through, as Chris mentioned, the special commissioner's hearing, we get access to your property and we can begin its construction, at which point we've got what we want, and if it takes us a much longer period of time to get to the final result, well, that's okay. I will say, Chris, for y'all's, our firm has never litigated against the city of Fort Worth, and y'all's acquisition rate is commendable. 85 to 90% is a pretty high rate. I will say this, and this is not a statement about the city of Fort Worth, but it is a statement about some of the oil and gas companies in particular that condemn property. They are very aware of what their acquisition rate is, i.e. the acquisition rate is the amount of Texas landowners that will accept your first offer or a very closely negotiated number from that offer. Okay, now you have to ask yourself, what incentive does that create for the entities offering the property? Typical acquisition rate for most of the folks I talk to, and a lot of the entities that take property are very secretive as to what that percentage is, but anecdotally I'll tell you I think it's between 60 to 80% on average across the state, project by project. Now, there's highs and lows to that, but that's, I think, a rough number that's pretty reasonable. If you're a for-profit oil and gas company and you know that 60 to 80% of Texas landowners are going to take your first offer or a closely negotiated number off of your first offer, and you're in the business of building that project as cheaply as possible, does that incentivize you as the pipeline company to make a fair market offer to acquire that right away? Or does it incentivize you to make a number or make an initial offer that is below fair market because you know 3 out of 5 or 4 out of 5 of the landowners are going to accept that offer, and then you just fight with the 1 out of 5 who's left, right? So I'll tell you that high acquisition rate, which, Senator, you're right, it's because many landowners are simply scared to fight or just are concerned about the length of the fight or the cost of hiring an attorney. It's not that they like the number in many instances, and Chris, this may be one instance where you and I would disagree. we have clients all the time who settle cases. They're not happy with the number, but they're concerned about what the long-term fight looks like, and they'd rather just fold their cards and take what they can get. So I'll tell you, that acquisition rate plays into, in our opinion, a negative incentive for the entities that take property to come in with a low value to start, to try to wipe off the map 60 to 80% of the folks that they need the right-of-way from.
Yep.
I'd like to say that there's an idea that we can't have roads, we can't have pipelines, we can't have power line corridors or railroads without eminent domain. And I don't think that's true. In the 19th century, there were a lot of private toll road companies. There were pipeline companies. In the 20th century, railroads that would go and negotiate with landowners and get rights of way without having the power of eminent domain. And the way they would do it often would be that they would outline 2 or 3 different routes with 2 or 3 sets of landowners to deal with, and then just say, look, we've got $20 million and we're going to distribute it to the landowners along one of these routes. Some of these landowners are going to win a share of that $20 million, whichever ones come to the table with us first. And then they'll negotiate, and with those options on the table, they end up having the same kind of negotiating power as if they had eminent domain.
Mm-hmm.
Well, and if I can add on that real quick, an interesting point, Randall, exactly what you said. In 2009, there was a company called Florida Power and Light. They needed to build an approximate 50 to 60 mile high voltage 345 kV power line out in the hill country, Fredericksburg, Gillespie County, Kerr County, that part of the world. They decided for business reasons not to go through the steps to acquire the power of condemnation in Texas, because they saw a need to build that line quick to be profitable. So it's the only instance that anyone in our world is aware of recently where entities came in without the power of condemnation and did what I would call a substantial project, not just one parcel. They took right away from hundreds of parcels in those counties. And what you found was that the amounts of money that they had to pay when they truly had to negotiate in a fair market, because they did not have the power to condemn, was higher than what we see in a typical condemnation context. So again, we use that as just simply an example to suggest that when you have to do it via condemnation, what it often, if not always, results in is a number that is depressed from what the fair market would actually recognize.
Questions among the audience?
One in the back.
Behind you.
The man in the far back. You were the first hand up.
Yeah, I'd like to ask Randal to comment on one of the sneakier villains in the eminent domain business, and that's metropolitan transit authorities. I know in Houston, at least, and I know in Austin you haven't gotten caught up in the light rail scam too much so far, but one of the sneaky things you'll find out about metropolitan transit authorities is wherever they decide to put a transit stop, they reserve the right to claim by eminent domain anything within 1,000 diameter circle by the transit stop, because that's supposed to attribute to density and transit-oriented development. And I wonder if I could ask Randal, because I know he knows a lot about mass transit, as to how that goes down with the Kelo decision, and have states wound up passing laws that have prevented mass transit agencies from condemning things around transit spots.
Well, unfortunately, it's more the other way. There's this myth that rail transit leads to an enhancement of property values. And it might if you have a rail line like in Washington, D.C. or New York City, where there's hundreds of thousands of people using the line every day. But light rail tends to be tens of thousands of people. Streetcars are thousands of people a day. That's not going to change property values at all. But based on that myth, transit agencies want to reshape how Americans live. They think Americans, instead of building a transit system that serves Americans living in their current communities, they want to reshape how you live so that you will serve their transit system. That means packing more people into high-density areas around transit stops. Austin is very lucky to have voted against the light rail here, because they would have seen that kind of a social engineering. It's so bad that in Portland and in Denver, they've actually said they are not going to allow any more single-family homes. All new housing will be high-density housing next to a transit stop. In Denver, the state legislature gave the transit agency the power of eminent domain and said, if you take away half of somebody's property and you build a rail line there, you're going to enhance the value of the other half of the property, so you only have to pay half of the market value of the property you're taking, because it's going to do such a great job for the other half of the property. And so they've been doing that. So be very glad you don't have light rail in Austin, and wish you didn't have it in Houston and Dallas.
Mr. O'Toole is pointing out why everybody's moving to Texas right now, so thank you for that. But
it's not for the light rail.
They're moving because they have no rights there. You're told what you're going to live in. But the problem is that some come here and say, all of a sudden, I think they yearn for that, and they try to inflict this on us.
No, there's this idea that California got to be where it is because of bad planning. And so, and actually it really got to be where it is because of too much planning. But so people move out of California and say, we want to make sure that what happened to California doesn't happen here, whether here is Oregon or Idaho or Texas. And then they say, well, let's adopt all these policies to make sure it doesn't happen. And guess what? The policies replicate California.
Amen.
This happened in Portland, where the buzzword was, we don't want Portland to become like Los Angeles. And so they spent years writing a plan, and then they compared their plan against the largest urban areas all across the country. And guess what? The outcome of their plan came closest to Los Angeles than any other urban area in the country. And they said, boy, that really is peculiar, but it's not going to change our plan.
All right, moving on to the next question, sir.
I have a question for Mr. Ellis. When a landowner chooses to fight the compensation, how successful, can you give us an idea of how successful those fights are? How many have you won? I mean, what are the odds of prevailing in a situation like that?
Sure. So every case is specific. So if you talk to any lawyer who looks you in the eye and says, if I take your case through a jury trial, I'm going to get you X or Y or Z or what your recovery will be, you can't believe that, because obviously the jury trial process is very volatile. And if ultimately that's going to be the final arbiter of what you get, it's very difficult to make predictions there. I will tell you that at our firm, since 2009, since we started our firm, we haven't represented a landowner where they hired us and they haven't ultimately received a higher net overall compensation, even after accounting for attorney's fees and client expenses, than what they were offered at the time that they hired us. So we've had a strong history of success of getting our folks more money. Now, the question becomes how much more, right? And that depends on every case, and one of the things it really depends on is the landowner's willingness to go to the mat, because in order to get what I would call top dollar, close to that grand slam number, you've got to get very close to trial, or in some cases go through the jury trial. And this goes to the senator's point. The ability to finance that is very difficult for landowners. We have regularly in informal settlement conferences all the time. We have counsel for the other sides look us dead in the eye. They'll never say this openly in court, but when we negotiate, they say, look, our condemning entity, governmental entity, quasi-governmental entity, or for-profit pipeline company's got a heck of a lot more money than your landowner, and we've got the right to build our project now across your land. So if you want to fight us and let this thing go, we can wait it out. And if you do well at a jury trial, we had one 6 months ago, we got 20 times more than what they had offered from a jury in Johnson County. Their answer is, well, we'll put you up on appeal, and we'll fight you on appeal for 3 to 5 years, and we'll try to wait your landowner out that way. So there is room for more money, but if you want to go for the top end grand slam, you've got to be prepared to have a long and lengthy fight.
That happened to one of my constituents, and literally the husband and wife came to my office, and it was with a pipeline, and the lady finally, in complete fear that it would happen again, she said, I can't emotionally go through this again. I mean, she was seriously considering just selling her land and leaving because she didn't want to deal with it again, and how terrible and horrendous it was, what they went through.
Well, that we see that we deal with the psychological side of eminent domain all the time with our clients. And I'll tell you one thing on the context of power lines and pipelines. If you're a Texas landowner and you own a pristine piece of 100 acres and you get an easement, be it power line or pipeline, you become infinitely more likely to get a second or a third at some point in the future. The routing policies have moved to a point where there's at least some policy thought that rather than have spider webs of lines and easements all through the state, then once we start to develop corridors, we should build them out. So that's Good news if you're the person on the PUC route that doesn't get hit with the power line, but if you're the person who has angst over one, odds are over the next 10 to 25 years, you're likely to be the person who gets hit when they need to upgrade the power line again. They now run the power lines parallel to the existing line. So it can become a recurring problem, and you see folks sell property after the first one because they don't want to deal with it anymore.
Sir?
Yes, I'm a county commissioner from Tarrant County, and for the past 2 years, I've been working with a group of property owners in my precinct in the unincorporated area, fighting the water district. For the past 2 years, I have a sense that it would be a losing battle. 81-inch water pipe would be built or bisect through people properties, and they will be only compensated for a small section that the pipe run through, not to mention the danger if the water pipe bust. That may drown and kill their little kids running around the backyard. And I'm wondering about the transparency. Is there any regulation that would regulate a governmental agency in how they interact with the property owners without being so manipulative? I mean, I'm a county commissioner, and sometimes I'm intimidated dealing with these folks.
Can I
leave alone the regular, ordinary, everyday people.
Can I ask you, is it really a groundwater district, or is it what kind of
water district? Basically, we are responsible. They are planning to run water pipe and then feed it into the Dallas community area. But it goes through southeast Tarrant County.
Yeah, right. Unelected board.
It is an elected board, but it behaves very bureaucratic, and to me, in my opinion, almost dictatorial.
Mr. Ellis, you want to talk about that?
Well, I'll just say we've got a half a dozen or more clients facing what I believe you're talking about. This is the Tarrant Regional Water District. They're building a pipeline that starts, if you know where Henderson and Anderson County is, kind of getting into East Texas, and that pipeline comes in, runs through the south edge of Johnson, Ellis County, swings up into Tarrant County, and we've got a lot of folks that are in exactly that same situation. This pipeline is a monster. It's, in some cases, the pipe itself is 10 feet in diameter. You could drive a Mack truck through it. The easement that they're taking in most instances for this pipeline is 150 feet wide. They're taking the right, and you're exactly right, to place not just a 10-foot pipeline in that easement, but to place multiple, as many pipelines as they see fit in the future in that easement. So think about, you're a landowner, your easement gets condemned 150 feet, they place one pipeline in, but they take the right whenever they want, moving forward into perpetuity, to come back out on your land and put in another pipeline and another pipeline. And trust me, when they have to dig a ditch big enough to drop a 10-foot diameter pipe into it, right? That's not a quick and easy construction project on your land, and the inconvenience that you go through time and time again when they come out there is a big deal. Now, I may not be, Chris, you may be a better served, or someone else on the panel may be better served to answer the question from the government's perspective on how they address that.
We're going to have to close the panel. We hit our mark, and I'm getting the cutoff sign by 3 different people. So if everyone can give, please, a round of applause to our panelists, and thank you for coming out.